an academic exercise, so let me leave it at that. That it is an instrument or a document made by a person expressing his desire or intention regarding how his property should be disposed with after he's dead and gone.
All right. Thank you very much. Does a will, can it be oral, can it be written, or is it must it have a form, a particular form before it's called a will?
Yeah, a will can be oral, it can be written.
Okay.
But like the medical people say, that memory fades, records don't. Or say memory fails, records remembers. Or memory forgets, records remembers. So when you have record, the record will not fade. If a will is made in writing, then it will be there. And it can be expressed and kept, that some people may not know about it, but at the appropriate time they will get to know that this is the will. So the advantage of a written will over the oral one is much. It cannot be overemphasized. That advantage is enormous. When you make an oral will, but when you say will, it may look so huge and people may be thinking of it very far away. Like a story of, what I heard, one elderly evangelist was talking about cross-pollination. So he said a bee would take flower from a plant to another plant and all. And one guy listened with keen interest and then asked, do we have that kind of bee around our area? So he was thinking of a special bill. He didn't know that the rice he farms, every day cross-pollination takes place. And the bees do, and he forgot that when you go to a farm at a particular point, a rice farm, for instance, you see bees around it. That is the bees the evangelist was talking about. But this man said, do we have that kind of bee around our area? So when you say will, it looks so huge to people and they are looking at it very far. A person who says, when I die, bury me in Jos, don't take my corpse to the village. That's a will. Regarding where he should be buried. So even though I said it in the definition that is how expressing the intention or desire of how a person wants his property to be disposed with. It also includes even where he will be buried. A person could state in his will, say, I want to be buried in so place. He can also say, I want this pastor to be the one to preach at my funeral. If I die before him and all of that. He can also appoint a person who will oversee his estate, who will take care of his property and ensure that it is shared amongst his children and other persons as he has expressed in the will. So where it is written, it has advantage over the oral one. And sometimes it may be a question of saying, well, it wasn't like that, it was like that. But often, especially in our local, our native villages, people will gather their children and tell them, this is what I want, this is what I want, and all. That's oral will, expressing how his property will be disposed of when he is dead.
Thank you very much. That means, that is to say that customarily, wills are also acceptable. Once it is stated, the father calls his children and they are standing by his bed before he dies and he says a thing, it's considered a will.
Exactly.
Well, thank you very much. What laws govern wills in this part of the claim?
Well, there's laws, wills law of different states. There's also succession. What?
Laws of succession
Yes, laws of succession
of
and
various states.
of various states. So they are the laws that basically govern wills.
Okay. Oh, the Wills Act too.
Yes, the Wills Act. That's at the federal level in the case of Nigeria that is applicable throughout the country.
That's true. Thank you. What are the necessary requirements for a valid will? You know, when we talk about the Wills Act, you know, there are certain things that the law will look at to consider if this will is valid, if it is proper, and it's acceptable under our laws, whether it's the act or the laws that govern the various states. So what are these necessary requirements that you should look for in a will?
Yeah, here the necessary requirements are: one, the person making a will, the testator must be of sound mind.
Okay.
That the person is of sound mind at the time he was making the will. He was not under any form of infirmity of the mind or of the mind. Or it could also be that someone is so sick that is unable to be in a stable mental state. So, one, he must be of sound mind. Two, what he's disposing of must be his own, and he must be of age. A minor may not make a will. It's someone who is of age, an adult who the law regards as an adult. That's 18 years.
Okay.
In some places, it's 21 years. So for a person to be qualified to make a will, he must have reached that age. And I mentioned that he must be disposing of the property that is his own. You cannot go out to make a will and then dispose of property that is either family property or belongs to another person. It must be your own property that you have authority over, that you can dispose of in a will.
That is to say, you cannot give what you don't have.
You cannot give what you don't have. Nemoko non habet.
Okay. So are there any other requirements apart from this?
Yes. It must also be made in the presence of witnesses who will see the person sign the will, and they will also sign. Two witnesses.
Okay.
Yes, who are also of age and of sound mind. And when a will is to be made, the beneficiaries are not supposed to be privy to the contents or to know the contents of the will.
Okay.
So as not to bring some problems.
Okay. You saying that the beneficiaries are not supposed to know the content of the will and all of that. So how do they know that there's a will that exists if their father or whoever is making, their uncle, passes on when he dies? You know, he can't come and tell them, I made a will. So how do they come to know about that will?
Well, generally, they may know that there is a will in existence, but it's the contents that they're not supposed to know.
Okay.
But generally, it's lawyers that make wills or draft wills for people.
Okay.
When you say make, it will be as though it's a lawyer that puts whatever is there. No, it's lawyers that draft wills for testators. So when a person makes his will, it is prepared by a lawyer. So the lawyer has a copy of the will, and it is normally registered with the probate department or division of the High Court of that particular place.
Okay.
So it is registered in that High Court. And so the High Court has a copy of the will, the lawyer has a copy of the will, and the testator himself also has a copy. He may inform some persons that I have a will prepared by so lawyer, and all. He may also, normally people keep their wills with banks. They keep their wills with banks for safekeeping. The bank keeps it for safekeeping, just like they keep other valuables. And so when the person dies, the lawyer knows that the testator has passed on. He will inform the family, even if they had not known.
Okay.
Then they will get to know that the man made the will, and then it will be a day to be fixed for the will to be read. There are new innovations, like in the High Court Civil Procedure Rules of Plateau State 2020. It is now made a condition that the will is read in the High Court.
Oh, okay.
So when a testator passes on, an application is made to the High Court. The High Court gets to know that this person has passed on, and the date is fixed where the will will be read. So it is the copy that is deposited with the probate division of the High Court that will be read in the court. They normally inquire to know how many persons are going to be part of the event. So they will prepare for those people, and they will fix the time. So the will now be read in the High Court premises. And then the members of the family will get to know that this is the will and these are the contents. So the issue of saying it is manipulated, it reduces the tendency or the likelihood of the will being
challenged,
being manipulated. And so it also reduces the issues arising that may result to its being challenged.
Okay. You made a statement that the will is usually registered at the probate registry, at the probate in the High Court. If peradventure the will was never registered, does that mean it's not valid?
Yeah.
Because I know that certain persons, could make the will on their own without consulting a lawyer, which is very risky at times, but there are certain instances like that.
Yeah. Like I mentioned earlier, it reduces the suspicion. If a will is registered in the High Court, it reduces the suspicion that it may have been influenced, or it may have been forged, or those kind of things.
Okay.
Because when it is registered, at the death of the person who registered it will come with evidence. Normally, when you register, you make payment, a receipt is given to you.
Okay.
So you have to bring it at the time of death. So now, the High Court has been involved officially. So it takes away the likelihood of forgery more than where it is just kept somewhere that you don't know under what circumstance and all. A member of the family may have influenced or may have forged and all. So it's better that it is registered in the High Court.
Thank you very much. On the issue of who can make a will, I know you said a minor cannot make a will as long as you are 18 years and above. But in this part of the world, we know that certain persons are usually excluded in the sense of women. Can women make wills? Because, women at times are seen as even properties themselves. So, but now that things are changing with the law, can a woman make a will? And even customarily now, can a woman make a will?
Yes, when you say customarily, well, let me answer the statutory side first.
Okay.
Statutorily, there is no impediment
regarding
making of a will by a woman. A woman can make a will so long as the property she is set out to dispose of is her own.
Okay.
So there's no limitation. However, when you say customarily, the custom, even in one state where you have many tribal groups, you find that the customs may be different, may differ from one place to the other. In some places, women are regarded as property. So they do not even have property themselves to dispose of. But in some, it is allowed. They can dispose of their property the way they want. So in such customs, there's no limitation. In those that a woman is regarded as property herself, then she will not have any right over her own property or any property to dispose of, since she is herself the property of another person.
Okay, but is that not in these present times? Is that not a way of disregarding the woman? And you know, those kind of laws, should we still have them, or those kind of customs? Yes, we say laws or custom as long as it governs a group of people. I think that is against the principle of natural justice, equity, and good conscience. I think such laws, I think the courts have helped in reviewing and revising some of those customs. And I think those ones who have still held on to such customs that think women as property, I think, you know, those customs too should be revised by the courts, and it will help, I guess.
Yeah, well, you see, since the coming of the Europeans to Africa,
Yes,
they brought about validity test for customs, for native law and custom, which was that the custom should not be repugnant to natural justice, equity, and good conscience, no, incompatible with any law for the time being in force.
yes.
However, till today, you still find that some customs are really obnoxious, and the people hold on to them firmly. Even in the upbringing of children, you hear a woman tell her daughter, "You are a woman, you have to be doing house chores, you can't be going about like a man and all." So women are even themselves feeling that a man can afford to go about aimlessly. He can afford to go about. He can afford to do yawo. But a woman should not.
Okay.
But generally, a human being should be responsible. But it's even women that are bringing up their girls to not indulge in yawo. But they don't bother about the boys. Yes. So what I'm trying to say is that for some people, the customs are so inherent in them. They have so embedded the custom that they don't want to deviate. They don't want to depart from them. So at all times, they are guarding them jealously. Sometimes even the women you think they are being discriminated against are the ones that are pushing
for the customs,
for the observance of the obnoxious customs. Something happened that I was very angry. My cousin had issues with his wife. And what was it? The guy was hanging out with other women, and the wife was not happy. And an elderly woman. So we sat down to discuss it. Me, I was just observing. That was many years ago, I think over 10 years ago. I was just observing. By the way, that my cousin is older than me. So we sat down, we're talking. And an elderly woman told the young woman, say, a woman does not insist on certain things with a man. And what was so annoying to me is that these are Christians. The elderly woman is a Christian. So you don't see anything wrong with a man pursuing women outside, womanizing and abandoning his wife. And you are even encouraging the young woman to bear it and not complain.
You know,
these are cultural beliefs, these are customs that even women think they are okay and they move on with them like that. So it will take a very long time before you get to a point where those obnoxious customs are eliminated completely.
That's true. Thank you very much. We've spoken about the necessary requirements for a valid will. The issue is, if I make a will, I know that many people find it difficult to make wills because, there's this thought and there's this myth that once you make a will, it means you are planning to die the next very soon. And, in this part of the world, death is like a taboo. But of course, death is inevitable to all men. So, but if I make a will, can I change it? Can I make corrections? Because at times, like, the fear is if I make a will and tomorrow, okay, I acquire another sort of property, it means that one will not be included. Or if I get angry with one of my children, and I feel like I should not even give anything to this one, can I change my will and remove him or her from the will? All of those things come into play. Or I give birth to a child much after when I have written my will. Does that child also, does that mean that that child cannot get anything based because I have written my will already? So these are scenarios and these are things that people keep thinking and asking questions about. Can one change or make corrections, or can I add, can I remove from what has been written, as long as, and since we have said that most wills are registered?
Yes, you can change your will, or you can alter your will in a manner that suits you.
Okay.
It could be just by an addition to what is already there,
Okay.
with what is called a codicil. Just making an addition to the will, disposing of properties that were not acquired before.
Okay.
But even then, in a will, properties that are not acquired at the time of making a will could be taken care of in the will. There's usually a clause that deals with properties that will be acquired after the will has been executed. Yes, so that can be taken care of. However, that may be inadequate. A person can now, with a codicil, which is like a small will, add to what has been done. He will make reference to the will that was executed before. Say he had executed a will on so date. He is now making this in addition to what had been made before.
Okay.
A person may completely revoke the will he has made before.
Okay.
A will opens with a clause like, this is the final will and testament of so person. Then the next clause could be that all other wills that were made before now have been revoked.
Okay.
So once that is said, anything that predates that particular date has been
revoked.
Okay. Has been revoked. I wanted to use a milder word that anyone will understand.
Maybe cancelled?
Yes, has been cancelled. Okay. So it's no longer valid. It can no longer be referred to as a person's will.
Okay. So the present and the one made thereafter is the subsisting will.
Yes,
and that's the one that is valid and that will be read if the person passes on.
Exactly.
Okay. Thank you very much. We'll go on a short break. We'll be right back. When we come back, the phone lines will be open. The number will be beamed on the screen, so you can make your calls and your comments and contributions to the show. We'll be right back shortly. Welcome back to the show, The Lifeline. we've been discussing the topic wills. And with me in the studio is Barrister Stephen Ahile. And we have discussed what a will is, who can make a will, and what constitutes a valid will. Barrister Ahile, from our discussion, we've been able to talk about, we just talked about whether you can change your will, you can amend it, you can revoke it. So, but we want to find out, when does a will take effect? Does it take effect from the date it was made, or is there a different, will it take effect thereafter or something?
Yeah, even the Bible says it. I can't remember the verse now in Hebrews, but they say a will takes effect from death.
Okay.
It's after the person is dead that the will takes effect.
Okay.
Yeah, it must be proved that the person is dead before the will become effective.
Okay. Valid.
Yeah.
Okay. All right. So, why is it important and necessary to make a will? Because I know that majority of people, I was reading and they were giving the statistics that 8 out of 10 persons have not made a will, and 7 out of that 10 will not make a will before they die. So why is it necessary to make a will, and what are the fears, that people have that makes them not to want to put down, in writing their wishes and their wills? And many people have so much property, some people feel, I don't even have anything. So what do I want to will out to somebody? So please, can you speak on this?
Well, yeah. Generally, people don't want to make wills. I've not made one myself.
See,
so I'm part of the 7.
You're part of the 7 that might not ever make a will.
No, well, maybe I will make.
Okay.
But sometimes I just feel that, well, there's nothing much to will out, and that I know that there won't be much issues when I pass on to glory.
Okay.
So I feel like that. But, well, you never can tell. The truth is that you never can tell. A lawyer said he sat down to make a will. And then he imagined himself lying down dead. And then he started crying. And that was how he didn't make the will. So it is not easy to make a will, but it is important to make a will. There are advantages of making a will. And these include that you know that you have given a direction on how you want your property to be disposed of when you are gone. So it is, your mind is better at peace. And then again, it's easier. When you make a will, it is easier for people to take possession of your property after you are dead, especially landed property.
Okay.
It is easier to process a will, to process the reading of a will and taking possession of the property than trying to get a deceased person's property who died intestate. That's who died without making a will. It could be money in the bank. You have to process letters of administration. They are more expensive, and it takes longer time and all of that.
Yes.
Longer period of time and all of that. There was a lady that the husband died and left. That's almost like 10 years ago. I think over 10 years ago, the husband left over 4 million in the account.
Wow.
But it was very difficult. They were looking for money, and they were required to pay almost 300,000 to the High Court registry as percentage of that money to get access to the letters of administration.
Okay.
Because it takes a long process. You file application, it is published, and then for 28 days to pass first before they will process your application. Those 28 days are allowed for anyone who has
an objection,
to bring same. So when a will is made, it doesn't take that long process. It doesn't take that expense. In a will, a person can even make provision for his burial expenses from his estate, and it's easier since this will is easier to access such funds than where the person dies without making a will, and the letter of administration is to be processed. So that's one. Second, thirdly, it also removes the issue of people wanting to take particular things from the estate of their deceased parents. It is easier as compared to where there is no will. Everyone wants to take a particular thing or is eyeing a particular thing, but where a will is made and the children, normally is children, and even uncles respect the person's wish. It is easier. The issue of dragging over property is less.
Okay. Areas where, like in the areas of where women, are disenfranchised from, at times, customarily, from inheriting, their deceased parents or husbands. Don't you think that this would help too?
Yeah, very well. Where in customs where women are not meant to inherit, if a person says this property is given to this daughter, it will be easier than if he didn't say anything. And then some people are coming. In some places they feel that even the woman should be inherited. So even though it is obnoxious to imagine that a person will inherit his brother's wife, but customarily in some places a woman is meant to be inherited by his surviving by her surviving brother-in-law.
Okay.
And some people hold on to it. I was sharing this story that in one particular community, the first university graduate in that community wanted to inherit his father's wife. Wow. And you can imagine that a person will want to inherit. This is an educated person. So you won't say he's an illiterate, but that's what he wanted. So some people today still feel a woman should not get anything.
Thank you very much. We'll take a short break now and we'll be right back. Thank you. You're welcome back to the Lifeline. We've been discussing the topic on wills. The phone lines are open, so you can make your calls and contributions. We were expecting Barrister Joseph Damboy. He's in the studio. He's welcome. You're welcome, sir.
Thank you very much. I really apologize for coming here late due to circumstances surrounding my trip.
You're welcome, sir.
Thank you very much.
Yes. Sir, you've come to join us. So we've been discussing the topic wills. We want to find out, can a will be challenged? You know, we said wills will be registered, wills will be read, and all of that after a person dies. But the issue is, can a will be challenged? Can somebody say, I don't buy into this will they are reading. I'm not in agreement with this will that was made. Can it be challenged? And who can do this challenge? Who can throw in this challenge?
Yes, a will can be challenged. That would depend on the circumstances surrounding the deposition of the will.
Okay.
If the testator, at the time of making the will, didn't sign the will, that will can be contested.
Okay.
That is one. Secondly, at the time of signing the will, two witnesses must witness the signing of the will by the testator.
Okay.
They two must sign at the same time as witnesses in the presence of one another.
Okay.
If at the time the will is being read and any of the testators, any of the witnesses denies being there at the time this man signed the will would be questioned.
Okay.
If the person who deposed to the will is a minor, and is not up to the age of depositing such will, definitely it will be contested.
Okay.
And if the circumstances surrounding the making of the will is questionable, for instance, the man at the time of writing the will is not in a proper state of mind to depose to that will, and you see the contents of the will, it will go contrary to what most of the family members will be anticipating, they can contest it. But at that time, he was fit and properly in a proper mental state of mind to depose to that will.
Okay.
And if the will is shown, this may be difficult, not to have been deposed to voluntarily, that will be a question. For instance, somebody has 2 wives and children, and the first wife is late. The second wife is so close to this man. Every time they are together, and towards the end of his lifetime, circumstances have shown that she maybe took him to the solicitor, she's always taking him there, and so on. And even when the will was, the draft of the will is being prepared, she's there with him, she witnessed all that he was telling the solicitor. Obviously, he will not say certain things that he desired to do. Under such circumstances also, you can contest the will. Basically, the will must meet certain criteria. The man must do it voluntarily, out of his own free volition. It must not be influenced by any person. And the will also must state the estate, what is given out. If you just make a will and you do not define the estate that you're giving out, you've not made a will. It's just like, let me give you an example of the Bible. The Bible contains God's will. Everything that has to do with us is there in the Bible. Every chapter, every verse that has to do with the child of God is contained there because that is His will. You find everything that the Lord made it specifically clear. Everything that pertains to us and life is contained with. That's how the will is supposed to be. So such circumstances may create doubts through which this will can be contested. And that's why most times also when you depose to such wills, the will is not supposed to be in the custody of the beneficiary. You're supposed to keep it in the custody of independent person, maybe a solicitor, even the bank, or in the probate registry. Until after the demise of the person, that is when it will be mentioned to the family that there's a will. The solicitor now writes the letter saying, okay, this man has a will. And at the time the will is open and read, most of these things will start, coming to bear. People will start asking, is this there? Is this there? And this is a time somebody can now say, okay, I'm contesting the will. You cannot contest a will that you have not seen. Yes.
Okay. So it means that that is to say that it must be one of the beneficiaries that can contest the will.
Yes, any person can do that, because particularly if you are part of his family, immediate family, and it so happened that you are not mentioned in the will, and everybody expect that this person should be in the will. Just maybe my dad is late, and I'm one of his sons, and then I discover that my name is not there in the will. I'll start asking myself, but there are some people that can be deprived the benefits of whatever inheritance will come. Maybe his attitude.
Okay.
The guy must be a rascal and so on. Maybe he's a stubborn child. He has been stealing from the man's estate. He has been selling many things. He may just deprive him of his estate. And at times you discover that in advanced countries, somebody may will some things to charity because he doesn't believe any of his children should benefit from that estate. So circumstances are there that may push people to challenge a will. But the other thing is, one thing is for you to go and challenge it, but the other thing is for you to succeed.
To prove it.
Yeah.
Okay. Barrister Healy, do you have anything to add to that?
Yes. That that if it is also, I think you mentioned this, that if it is also shown that one of the beneficiaries knew the contents of the will, it could also be challenged. But the challenge, of course, is subject to proof. Because if you are just challenging for challenging's sake without cogent reasons why you are contesting the will, then it will be an exercise in futility.
Thank you very much. Barrister Damboy, please, we want to know, is it right for a Christian to make a will? Or is not something we should consider as believers or as Christians?
It is right if the Lord will have his will written in the Bible. Why don't we write our will?
Okay.
You know, it's right for a believer to write his will because the will speak after your death. You see, most times people think if I want to depose your will, negatively I'm thinking I'll soon die. Well, it's appointed unto man to die once. Everybody must die.
Yes.
You know, and one of the best way to solve the major challenges we're having today in this complex society is to depose to a will. Because it takes your family away from issue of culture, traditions, and so on. You find a family that have stayed together with this man, and this man or this woman dies. You see relations coming in to apply tradition. This is our brother, and this is what we think should be done. But the will should speak to him after his death, because he has already appointed administrators of his will. And the idea to make sure that every letter of that will is being met. You know, if there's a child who is maybe 17 and his own part of the shares should be kept until he becomes 17, this man will ensure that these things are done. But you see, in situations where you decide not to have a will, and then the person dies, the next thing is that the widow will go to apply for letter of administration.
Yes.
Another person will come as an uncle or a brother to the person and then enter a caveat and say, no, she cannot be an administrator. We have to be administrators. So if you don't do that, somebody else who you don't want will now administer your property. And the concept we have today is, well, and I'm the administrator, you go and collect every money. You find an uncle going with about 50 million, holding it as an administrator. His children are there, but they will not have anything out of it. And he thinks that as an administrator, I am the owner of the property or the money. But you are supposed to be a manager. So if you don't have in your will the person who will manage your estate the way you desire it, someone else will do it.
Sorry, I have to cut you short. Moses from Nasara, thank you for calling. You can make your comments where you're on air.
Will.
Hello.
Then what when next of kin will.
Hello. The line is breaking. Please, can you speak up? Hello. We lost that call. Sorry, you were talking on administrators.
Yes. I was just saying that if you don't have the will, because if you have your will will state who is going to be the executor of that will. And specifically, you have mentioned your estate and other properties that are subject to inheritance. You've allotted it to every individual. And your administrator, the person who is administering your will manage it and make sure that these things are followed to the letter. But in the absence of a will, you know, any person can come, do anything with your property because he's an administrator. He has applied for letter of administration because most times the culture we have here is the widow is not always seen as somebody who is trustworthy to administer the estate of her late husband. Somebody else will want to come. Especially if she have grown-up children that can stand for her and say, well, we are matured enough to administer the estate of our father. Then the widow and one of the children can just be the administrators. But having a widow who has maybe children that are minors, people would think, well, she wants to go away with her brother's things and so on. So one of his brothers is supposed to be an administrator with her. And you see, so these are some of the consequences of failing or refusing to depose to a will. So it's Christian for you to have a will. Because if it's not proper, the Lord will not have his will. They will have the New Testament and the Old Testament. These are testaments that contain the will of God concerning us. So it's right to do it as a Christian.
Okay. Thank you, Sunday from Ekiti. You're on air. You can speak.
My question. This is my question.
Okay.
If a will by somebody, and now one of the property before his death is the will
Sorry, your line is cracking. Can you come again?
If somebody and the will, is that within?
Because the network is bad.
So, sorry, your line is breaking. You can call back so that we can hear you properly. Thank you. Okay, so we will go on. Sir, you mentioned administrators of the will. Is there any role of the next of kin in the issue of administering the deceased's property?
Yeah, well, you see, once there's a will, the issue of next of kin is not really relevant because most times people have in their employment letters. Most times when you are employed, you are asked to mention your next of kin and so on. Your next of kin is that person who will step into your place and then collect these entitlements.
Yes.
Yes. And at times you discover that even with the next of kin, the organization will desire that the next of kin should go and apply for letter of administration.
Okay.
So that the letter of administration will give him the powers to do the administration of the property because it is brought under the confines of the law now. And this next of kin now will go. I have an example. Somebody is the next of kin. He went to apply for letter of administration and the relation said, no, you cannot. You have to be part of it. And they jointly now applied. The wife is the next of kin in the place of work.
Okay.
And then the man now died. So she now went to obtain letter of administration.
Yeah.
And somebody just whispered to the family and the family came and entered the caveat. It was a war. It was a war. And you see, this widow have to cave in because the moment she goes and stand to say, no, I'll stand by this, they say, after all, you are the person that killed our brother. You have no right to defend the estate of your husband. If you do that, the interpretation is you have a hand in his death.
In his death.
You get it? So they now went to court and then got a letter of administration. So both of them became administrators of the estate. And when they submitted this thing to the organization now released the funds to both of them.
Wow.
But you see, the point is that people still don't understand that even as an administrator, it is a risky thing to do that. People think if you are an administrator, the money comes to you, do whatever you want to do. No, you are a manager. You manage the resources or the funds of that person. You are holding it in trust. And that's where any of his children and the beneficiaries can file a motion to the registrar, to the court, calling for you to give account of your administration of the estate.
Wow.
And if you fail to do that, you'll be sanctioned. Either a fine or you go to prison.
Sorry to cut you. Sunday from Ekiti. Sorry, we can hear you now. You can go on.
Okay.
Hello.
This is my question.
Okay.
Good evening.
Good evening.
My question is this. If somebody made a will and before his death, he sold one of the properties will to somebody inside the will, is that will still genuine or it's not genuine again after his death?
Okay. All right. We'll answer that. Okay. His question is, if you make a will and in the course of while the person is still alive, he sells off one of the property, that is in the will, is that will still valid even after he's gone? Barrister Damboy, you want to say something about that?
Yes. You see, most times people have deposition in wills, and at times you may discover that somebody who is supposed to be a beneficiary of the will may even die. Sometimes you may have additional property. You may just depose to a will when you have about 20 properties or 5. Thereafter, you have 15. You may decide to sell 1 or 2. The law permits the person who has this will to have a codicil.
Okay.
A codicil is an amendment to your earlier will, because you may decide to change your mind concerning property A or property B. You may have additional property. So the codicil is another provision. Okay? It's like the Old Testament, and then you have the New Testament again. You understand?
Yes.
So the codicil is there. You can have at least even more, about 3 or 4 codicils.
Okay.
So you have a will, you can amend it, because as you buy more things, you do that. If you sell 1 or 2 other things, you can have it by way of amendment of the will. Somebody who's supposed to inherit your estate may not survive. You may leave even after that person. So you can also amend that.
Okay.
Yes.
Thank you very much. This is the much we can take on the show this evening. It's been an interesting discussion we've had. We had Barrister Damboy on in the show and Barrister Ahile. You can join us same time next week. We'll be discussing another very interesting topic. Until then, ensure that you make your will. And the best way to prepare for that is to surrender your life to Christ, and do well to also make a will to help your families or relations after you're gone. Thank you very much. Join us same time next week.